So, Mark, if I sell you 125 bags of sugar for £1 each, but I only deliver 124 of them, you don't have to pay for the 125th bag, right?
Well, I certainly won't be paying you for it.
Okay. And if you've paid me already for the 125th bag, you can get your money back, can't you?
Well, I want my money back.
Okay, and that's because there's been a failure of consideration in respect of that 125th bag, and the contract can easily be severed to treat it as 125 obligations to provide 1 bag of sugar.
No, it's not it at all, because I've got a claim in damages for breach of contract for short delivery, which I can set off against the purchase price or I can counterclaim for. It's got nothing to do with consideration. The consideration would only have failed if you didn't deliver any sugar to me at all, or if we had 125 separate contracts.
Oh, well, okay. Now, I thought you might say something like that, but it's that last bit that's important, isn't it? If the contract can be treated as 125 separate obligations to deliver a bag of sugar each, you can view it as a failed consideration case. So similarly, if rent is reserved yearly, isn't there a separate contract for each year? So if I grant you a lease of, say, a cinema or a restaurant for 125 years, but because of the coronavirus regulations, you can't use it for one of those years, you don't have to pay rent that was reserved for that year because the consideration for that year's rent has failed. There we go, done, sorted.
I don't think it's quite that simple, Bear.
Oh, it never is with you. Okay, well, look, it's a bit of a shame that the recent case, the Bank of NY Mellon case, doesn't really deal with failure of consideration in any detail at all. So, okay, let's discuss some of the objections to the failure of consideration defence and why it's not that simple.
All right, let's start with a technical point. An oral contract is enforceable if it's supported by consideration. Otherwise, it's nudum pactum, which isn't nearly as exciting as it sounds. But leases for more than 3 years have to be by deed. And a promise and a deed is a covenant, which has never needed any consideration at all to be enforceable. So what's failure of consideration got to do with it?
It's a bit of a cute point, that, isn't it, Mark? I mean, the rent is typically expressed as being reserved in consideration of the demise. And failure of consideration is just a label, really, for paying money and not getting anything in return. It's an action for money had and received.
Okay, I admit it. It's the sort of point you might try on with a deputy district judge if you haven't got anything better and it's a bad afternoon. And of course, it doesn't matter that you've paid the rent because the court isn't going to order you to repay it, isn't going to order the landlord to repay it after you've paid it. It's money hadn't received to your use. But there are more serious objections to it, aren't there?
Okay, let's take a second one. It's often said that the failure of consideration has to be total. And in fact, in the recent AEW case, the Bank of NY Mellon case, Master Dagnall, who only dealt with partial failure of consideration in 1 page of a 101-page judgment, said that partial failure of consideration isn't a freestanding doctrine of contract law. And I was a bit surprised to see that because there are cases which deal with this severability point. If you can sever up the consideration, then you just have to have total failure of consideration in respect of that separate severed obligation.
I think I agree with that. It's true that it's an open question whether failure of consideration has to be total. But Lord Mansfield, who invented the doctrine, never used the word total. Mm-hmm. In any event, even if it does have to be total, I think the question must be whether there's been a total failure of consideration for the particular payment. So if you're looking at each scale of rent and asking whether the consideration for that payment has failed, it's a question of looking at what that payment was for. Where rent's payable in advance, however, I can see problems where you've had some use during the particular quarter, because of course, Marks and Spencer's in the Supreme Court says that the fact that you didn't get some use during the quarter isn't a reason for getting the money back.
Mm-hmm. Yeah, okay. Well, look, there's a third issue which is often said, which is that, well, the tenant is still being able to make some use of the premises for the duration of the quarter or the year or whatever. So even if the restaurant was forced to close for dine-in guests, it can still operate as a takeaway. Even if the shop was forced to close, it can still store stock there. Say that 100 times quickly. If the cinema was forced to close, then perhaps there's a back office that can still be used for administrative staff. So it might be said there that actually you don't have total failure of consideration in respect of your quarter in any event.
Well, you know, I watched a very good PLA Scotland webinar in March on the impact of COVID on leases, where I think it was Scott Stiles of Aberdeen University said that he gets his contract students to chant, "It's not fair, we don't care," teach them about contract law. And I thought, well, they're going to get a shock when they go to court, because it's only appellate judges who care about law. Trials, it's all about fairness. If the consideration for the rent is the beneficial use of the property, it's not going to be easy to persuade a judge that a bit of involuntary storage while the premises are compulsorily shut counts as beneficial use of the property consideration.
Yeah, okay, well, we'll have to see how that one plays out for sure. Yeah.
I think, however, there's a more fundamental problem.
Mm-hmm.
The consideration for the rent isn't the beneficial use of the property. The consideration for the rent is the continuing existence of the lease. That's why tenants whose houses were burned down in the fire of London or were blown up in the Blitz had to continue paying their rent until statute intervened to relieve them. And it's why tenants of properties that were requisitioned during the war had to carry on paying their rent.
Yeah, okay. Now, I was thinking about this because I was reading the EMA case again, which of course is a case concerning frustration, where the EMA's lease of its premises in Canary Wharf following Brexit could potentially not have been used. Now, Mr. Justice Marcus Smith found that there had been no frustration for various factual reasons and legal reasons, but really helpfully considered some alternative cases, and in particular, the alternative, the counterfactual basis that the EMA could not lawfully occupy the premises because of Brexit. And on that assumed basis, he said that the lease would have been frustrated. So for the purposes of frustration, a demise alone, which you can't then lawfully occupy, is good enough. Lawful occupation has to be possible for the lease to continue. So can't we say the same for failure of consideration?
Well, frustration is really a story for another time.
Maybe so.
We're coming to the end of our allotted 10 minutes. Where do you think we are on promulgating this heresy now, Ben?
Well, I mean, you know, we've had these two recent decisions, AEW and Commerce Real. Both decisions favoured landlords, and that's caused some tenants to question their prospects of defending these rent claims. But I mean, I think look carefully at these decisions, and they don't actually deal, well, the first one, Commerce Real, doesn't deal with failure of consideration at all. AEW barely touches on it. I think there's lots more to this argument. And of course, they're master's decisions, so they're not binding authority. It's all to play for. So let's watch this space, see what gets appealed and what doesn't, and on what bases, and see what happens. For anyone that has listened to us today, if you've got any interesting questions or bright ideas, then please do get in touch and we'd love to hear from you. But thank you for listening.